On this episode, we see how the Americans with Disabilities Act applies to sidewalks. Then we travel to California to talk with a lawyer and a plaintiff from a key court case. Stay tuned. We're in Washington, D.C., talking with Lois Tebow, who's the research coordinator of the U.S. Access Board. What is the Access Board?
You could think of the Access Board as the federal government's specialist in accessibility. We have the responsibility to develop guidelines under a whole range of laws that require accessibility, from the ADA, which governs buildings and facilities, to information technology, to voting machines, to telecommunications. Our work is generally for another agency that has rulemaking authority.
And when did federal law first get involved in accessibility of the public right-of-way, sidewalks, and so on?
Actually, quite a long time ago. In 1973, a law called the Rehabilitation Act required that programs that were funded with federal money provide a certain level of accessibility. It was a very basic level of accessibility. It's certainly gotten better since then, but the U.S. Department of Transportation's 504, the Rehab Act is often shorthanded as 504, standard, required curb ramps and things of that sort along public rights-of-way.
And you mentioned the ADA. What does that stand for? When was that passed? What does it do?
The Americans with Disabilities Act, which came along in 1990 and basically took two laws that had applied largely to the federal government and to facilities that had federal funding, often through the states, and applied it more broadly to virtually every kind of facility and entity except for religious organizations and private clubs, and to a certain extent housing, which was already covered by another law.
So how does the ADA apply to the public right-of-way, sidewalks, and so forth?
Well, the ADA has 5 titles, and 2 of them have obligations for entities that do a fair amount of design and construction. One is Title II, which covers state and local governments, and the other is Title III, which covers private sector facilities. It's Title II that is generally that will generally govern public rights-of-way, design and construction. But as we all know, very often it's Title III entities, developers, private sector providers who will actually design and construct the pedestrian facilities, but having to meet then the Title II requirements.
And how does the law get translated into what gets built? I mean, people don't go and consult law journals when they're about to run out and pour a sidewalk.
No, and I think that's one of the issues that affects implementation, is that the work of our agency and then of the agencies that adopt our guidelines are printed first in the Federal Register, which is not a document that everyone reads. When a law is passed, Congress assigns responsibility for implementing regulations to a federal agency that has an interest or a responsibility in that area. In the case of Title II of the ADA, implementing regulations were assigned to the U.S. Department of Justice, and in 1991 they produced implementing regulations. Then those implementing regulations will often include, and in this case they did, a reference to or an actual standard against which you can measure the requirement that the implementing regulations has. In the case of Title II, it says that new construction and alterations to the maximum extent feasible shall be accessible to and usable by people with disabilities. And then the guidelines that we develop become the standards that measure that accessibility, and in a way you could think of them also as a safe harbor for practitioners. So if you follow the Access Board guidelines, you could be deemed to be in compliance with the requirements of the implementing regulations.
What work goes into creating a set of guidelines for something like the public right-of-way, where you can't have one blueprint that's going to fit every intersection in the country.
That was something that we wrestled with for a long time. We, of course, started with the basic ADA accessibility guidelines, which were themselves based upon an earlier standard, the Uniform Federal Accessibility Standard. And all of those things were based upon research that was done, some for HUD, some for other agencies in the 60s and 70s. We did our own research. We had an advisory committee that helped us with recommendations. They represented the stakeholders, both public and private, and we had, in the end, about 55 members of what was called the PROAC, Public Rights of Way Access Advisory Committee. And we're now at the draft stage, and as soon as we get finished with our cost analysis, why we'll be ready to publish what is called a Notice of Proposed Rulemaking.
How difficult is it to measure the costs versus the benefits of making a corner usable by someone in a wheelchair?
It's extremely difficult. It's quite easy to monetize concrete or even construction labor, but it's very difficult to assign a value to the ability to live independently, which is really what it's all about.
And then what applies to new construction and what applies to fixing something that's already there that was built before we knew better?
This is a perfect opportunity to cite the flexibility of the ADA. There are 3 levels of expectations, if you will, under the ADA. One is for new construction. When you're starting from scratch, you can control every feature. You haven't assigned right-of-way yet, and so all of the provisions and all of the improvements that you design and construct can meet perfectly a standard. In an alteration, also governed by the standards, there's a great deal of design judgment, engineering judgment, if you will, available to the practitioner or to a jurisdiction, because the requirement is to meet the new construction requirements to the maximum extent feasible. This allows you to consider what's already been built at the location, if your street is in place, if your curb lines are set, if your adjacent building elevations are already determined. You have much less scope for what you can do to make an altered sidewalk accessible. And then there's a third requirement which isn't governed by the guidelines, the standards at all. That reflects requirements for existing facilities, and that's governed by the Justice Department implementing regulation, which generally requires local jurisdictions to achieve something called program access, a broad level of usability that may not be, depending on what's available to achieve it, that may not be more than very minimal accessibility.
Now, when over the decade and a half, going on 2 decades now, that the ADA was passed, what precedents have been set regarding what's an alteration to the pedestrian environment that would trigger having to do something?
Mm-hmm. This is an issue that has been a very hot one, I think, in the transportation industry. Because the Justice Department implementing regulations say that if you alter a sidewalk or a roadway, then you need to install curb ramps as part of that alteration. So the question was, what is an alteration? And there was a very famous case in 1993, we shorthanded as Jerusalem, and it was against the Pennsylvania DOT, alleging that they had resurfaced quite a number of roadways in the city of Philadelphia and had not provided curb ramps as the implementing regulation required. And in fact, that was the finding of the district, the federal district court in that case, that resurfacing a roadway constitutes an alteration that requires then that curb ramps, not anything else, but curb ramps, be included in the resurfacing project.
And then for existing infrastructure for program access, what
The-
guidance have we had from the courts on that?
The Title II regulation requiring jurisdictions to achieve program access has been, I think, greatly illustrated by the Barden case in Sacramento, California, where the finding of the well, actually, it was a negotiated agreement in the end, but the finding, I think, essentially is that pedestrian circulation is a program of a jurisdiction, of a city in this case, and that the city has an obligation to achieve program access. That is a basic degree of usability in their pedestrian circulation for people with disabilities. So Sacramento is now spending a substantial portion of their public works budget for the next, I believe it's 30 years, to ensure that gradually conditions are improved in the whole network of pedestrian facilities.
What's been going on, in voluntary agreements outside of the lawsuits and the courts suits?
There's been a recent agreement in San Francisco, negotiated there by a group of people with disabilities and legal counsel with the city of San Francisco, where the city has agreed to install over 100 new accessible pedestrian signals in existing intersections in the city. And in 2005, there was an agreement between the Maryland State Highway Administration and the Federal Highway Administration about accessibility in Maryland at intersections, resulting in an agreement in which the state agreed to install accessible pedestrian signals at new intersections when new pedestrian signals are installed, and also to retrofit some existing ones as part of that.
What does the future hold? We're seeing these bits of things happening here and there. What would you anticipate if we talked again in 10 years we'd see?
Well, we're starting to see, I think, a good deal of compliance with certain provisions. We see a fair number of detectable warnings going in. We see much more awareness, I think, of the 2% cross slope limit on walkways. Certainly, we see an active curb ramp installation program in many, many cities. While I see a lot of countdown signals going in, I don't see so many APS being installed. So that's an area where I hope that we'll see a good deal of progress, and maybe technological progress as well as installation progress. There are some very nice European models of APS that are very unobtrusive in the urban-suburban environment where noise can be a problem. But of course, the big issue is we hope, finalize the public rights-of-way accessibility guidelines, which have been developed specifically to guide construction in the right-of-way and improve on many of the areas in ADAG where it's not really very applicable. I mean, you're not going to build a sidewalk with level landings for every 30 inches of rise and handrails and things like that. So we've taken, I think, a good look at the public right-of-way and said what kinds of guidelines are needed to specify accessibility in this environment. We've gotten a lot of support from industry organizations, APWA, ITE, ASHTO, and of course our federal partner, the Federal Highway Administration. Can I highlight a new publication that
Sure.
all of those folks worked on?
If people want to know about this, what's available?
Yeah, it's a new publication called Accessible Public Rights-of-Way. It's actually a product of the Public Rights-of-Way Access Advisory Committee. But every industry organization contributed to its development in terms of staff time and member time. And it is basically a guide to dealing with rights-of-way requirements in alterations where you may not have control of the whole facility. You may have a narrow right-of-way, a steeply sloping site, cross-slope that's excessive, and things of that sort. So it's got some workarounds that we think will be very useful.
So what other guidance is available for someone that's building something now before the regulations are finalized?
Well, of course, the best thing to look at are the public rights-of-way accessibility guidelines, the draft form, which is published on our website, and all of our material is available on our website. The provisions for detectable warnings, for APS, and so on. A lot of harmonization with the Manual on Uniform Traffic Control Devices, with the pedestrian facility requirements of AASHTO in the Green Book. But all posted to our website. The Federal Highway Administration in 2006 issued a memo to the field recommending use of the draft guidelines as a best practice, particularly where ADAG is inapplicable or silent. So it's the best guidance that I think is available for construction in the public right-of-way.
We're in Berkeley, California, talking with Melissa Kasnitz with Disability Rights Advocates. What is Disability Rights Advocates?
We're a nonprofit public interest law firm that works to advocate on behalf of people with all disabilities, people with mobility disabilities, vision or hearing impairments, learning disabilities, developmental disabilities. We litigate on behalf of all of these groups, and we also try to provide education and advocacy to improve their civil rights.
What was your role in Barden versus Sacramento?
I was one of the attorneys that worked on Barden since it was first filed, I believe, in 1999. And we brought the case all the way up to the U.S. Supreme Court and ended up with a ruling that importantly requires cities to not just install curb ramps at intersections, but also to remove barriers along the length of the sidewalk.
What was the basis of the lawsuit? What were the plaintiffs concerned about?
The plaintiffs were concerned that they couldn't travel and do their daily business around the city of Sacramento using the sidewalks, and they frequently had to travel in the street because barriers kept them either from getting onto the sidewalk in the first place or from traveling down the sidewalk once they were on it. The plaintiffs included both people who use wheelchairs and people with vision impairments who also had difficulty navigating the sidewalks because of barriers.
What was the legal basis of the suit?
The primary legal basis was the Americans With Disabilities Act, which requires cities and other public entities to make sure that all of their programs are accessible to people with disabilities. We argued, and others have argued, that the system of sidewalks is a program of a city, and the city thus has an obligation to remove barriers and make the sidewalk system accessible.
What was the argument of the defendants, the city?
There were a couple of stages in the lawsuit. The first stage of arguing was about curb ramps primarily, and the question wasn't about the city's obligation to install curb ramps, but rather how quickly did they have to install them, how much money did they have to spend on them, how should they prioritize them. And we eventually reached a resolution on those issues. The second question, and the one that was fought for much longer, was what obligation the city had to address other barriers. And examples of these other barriers, because a lot of people don't think about them, are buckled sidewalks, whether tree roots or just wear and tear cause a sidewalk to buckle. That can create an abrupt rise that a wheelchair can't get over at all, or that is a tripping hazard for someone who's blind and uses a cane. Narrow sidewalks because they're street lamps or other street furniture that make the sidewalk so narrow a wheelchair can't get by. Overhanging, they're called overhanging obstructions in the regulations, things that come down low and a person with a vision impairment might walk into because they can't detect either tree branches or low-hanging street signs. Those are examples of barriers that exist in between intersections.
What were you eventually able to get the city to agree to in the settlement agreement?
Eventually, after a lot of battling in the courts, the city agreed that it had an obligation to address all barriers, not just curb ramps, and it agreed on an annual funding formula and a formula for setting priorities to install curb ramps and address other barriers throughout the city. So the courts finally established definitively that they have to address barriers other than curb ramps, and we sat down and worked together to come up with a portion of the city's annual transportation funding that will be used to address barrier removal.
And the case involved obstacles in existing sidewalks. What limitations does that give for if there aren't any sidewalks at all?
Unfortunately, because I know a lot of people are always looking for ways to require cities to install new sidewalks, access law is not a tool for that purpose. What access law is for is as a tool to avoid discrimination. So if there's an existing sidewalk and a person who uses a wheelchair can't get onto that sidewalk and has to travel in the street, that's discrimination, and the city has an obligation to fix it. If there are no sidewalks in an area and a person who uses a wheelchair has to travel in the street and a person who walks has to travel in the street, they're treated the same. There may be other legal tools that can be used to force cities to install sidewalks, but access laws can't be used for that purpose.
We're in Sacramento, California, talking with Jeff Tom, who's president of the California Council of the Blind. What is the council?
The council is an organization comprised of primarily blind and visually impaired individuals, but some people who are not. We've been around for more than 70 years. Our mission is to advocate for ways to improve the lives of blind and visually impaired persons, whether it's for better education, employment, transportation, and of course, few issues are more important than pedestrian safety.
And you were also one of the plaintiffs in the Barden case. What was the Barden case?
The Barden case was a lawsuit brought by residents of the city of Sacramento with disabilities against the city to enforce the city's obligations under the Americans with Disabilities Act.
And as the lawsuit progressed, you got involved in negotiations with the city. What happened there? What was happening?
Well, initially, the settlement discussions were proceeding fairly well. One of the problems that we had to deal with to some degree as visually impaired persons as was, interestingly enough, the fact that the legal rights organization bringing the lawsuit, sometimes they didn't even have enough information about the needs for our disability groups. So we had to be very conscientious about making sure that our issues were well represented, and I think we did this. And I think they learned from it, and since then they have become very cognizant of the needs with those of visual impairments. And in subsequent negotiations with other jurisdictions, they work very hard to ensure that our needs are met. But initially, the negotiations between the city and the disability community were proceeding fairly well. I think that one of the most notable achievements of those negotiations was that there were some initial concerns expressed by people with physical disabilities, those in wheelchairs and those, for example, who used crutches, that they were concerned that the design of detectable warnings, and detectable warnings, for those that may not be familiar with them, are essentially dome-shaped, tactile pieces that are put at the beginning of curb ramps so that those with visual disabilities and others can identify when we're about to come to a curb ramp so that we won't go out into the street because you don't have the large curb anymore to give you an indication that that the street is going to begin. And so curb ramps are required by federal law to have these detectable warnings on them. There were concerns by people with physical disabilities that these detectable warning designs were difficult for them to get over and to navigate. So the city, in what I thought was a very amicable and very professional way, actually designed some wooden ramps with various slopes to depict various types of curbs and curb ramps. They used various types of these detectable warnings, some that were sort of spread farther apart, some that were wider, that would depict different ways of having to negotiate across the street, and gave individuals with visual impairments and individuals with other disabilities the chance to walk on these ramps so that we could reach a consensus as to the best possible design for all people with disabilities. And during the course of these negotiations, we really reached an amicable view on what was best for everyone. And what could have been a divisive point among the disability community turned into something that I think should be copied, has been locally, and should be copied by others throughout the country, and that is to come together and to work collaboratively. And so I think that was really a high point, this whole learning and collaborative experience, a high point of the negotiations.
Were there times when the negotiating process didn't go so well?
Well, as negotiations progressed and it looked like we might be coming toward a settlement, positions hardened. The city, for whatever reason, decided that they really didn't want to agree to the terms we were trying to, the terms we wanted them to accept, and they hardened their position. They went to court to fight the idea that they had a legal obligation to meet any of the terms that we wanted. And we were fortunate that the courts were sympathetic to our position, and even the United States Department of Justice was coming in on our side. But still, there was a chance they might have gone up to the U.S. Supreme Court on this, and that's when I think we started to exert some political pressure. The disability community really mobilized and came to the city council and got some press coverage, and I think raised the eyebrows of the city council. They didn't want to look like they were not willing to make the capital city of California a model for the future. They didn't want to make it look like they were opposing disability access. So I think in the end, they were willing to reach an amicable settlement, and I think that as the future of that settlement has worked out, that everybody has been very happy with what they decided to do.
Visit us on the internet at www.pedestrians.org.